Hi, and welcome back. Now we take up another form of dispute resolution. This is called alternative dispute resolution. And we'll be focusing on two types of alternative dispute resolution, that being mediation and arbitration. Now, we know that disputes often arise in business, whether between a business and another business, or a business and its employees, or a business and someone who has been injured by the business. And as we learned when we were discussing litigation, resolving disputes in the court system can be expensive and very time-consuming. And so parties may wish to use a private means of resolving disputes. Alternative dispute resolution methods permit a cost-effective resolution. So in this lecture, we're going to look at alternative dispute resolution methods. Now, increasingly, business disputes are decided not in the court system, but outside of the court system. Now, historically, of course, disputes were decided within the court system. But beginning in the 1990s, more and more disputes were shifted into these private processes, in large part because of the numerous drawbacks we found with litigation. Now, there are different forms of alternative dispute resolution, and the first one, which we don't talk about a lot, but which we probably should, is negotiation. Negotiation is the simplest and least expensive alternative to litigation. Arbitration, which is a formal procedure, and it binds the parties to the result. And then mediation, which is an informal, non-binding procedure using the assistance of a mediator. This is essentially an assisted negotiation. Now, negotiation has advantages and disadvantages. The first being the parties can negotiate a resolution without the use of any third parties. And the advantages are plentiful, starting with the fact that it's very inexpensive. It's picking up the phone. It's sending an email, sending a text. It's completely confidential. The only parties that are aware of this negotiation are the parties themselves. It is time-saving. Negotiation can resolve a dispute relatively quickly. Furthermore, in a negotiation, the parties are already familiar with the issues and the facts. There's no need for education as we see with a jury. However, there are disadvantages to negotiation, and this is why it is sometimes difficult to negotiate a resolution. The first is that parties can become locked into their position. It is very difficult to comprehend other people's problems, and you may be unwilling to offer any compromise because you see that as a weakness of conviction, that as soon as you offer to take less than what you believe you are owed, or as soon as you offer to pay more than what you expected to pay, then the other side may get the idea that you lack conviction in your argument, and therefore that is a sign of weakness on your part. And so this is why we utilize other methods of dispute resolution instead of simply negotiating a solution. Now, mediation uses a neutral third party to resolve disputes in an informal procedure. Mediation is designed to facilitate an early resolution of the dispute before the parties have been engaged in the process for too long or before the parties have spent too much money. Now, generally, all legal disputes now are subject to mediation. If the parties don't agree to mediate voluntarily and they initiate litigation, it is often certain that a judge will require the parties to mediate the case before the judge will take it to trial. So I say that most legal disputes now are going to be mediated at least once. Now, sometimes there's an agreement between the parties. In the contract itself, it may provide for mediation. And again, usually courts will always order a dispute to mediation before trial. Now, there's a lot of advantages to mediation, starting with the idea that it too is private, it is confidential, and it is inexpensive. Most mediations are heard within a day, only a day-long mediation, and so that's going to be relatively inexpensive. The mediators themselves are rarely very expensive. And so mediation can be inexpensive, and of course it's confidential. Not quite as confidential as negotiation, as you do have to tell things to the mediator, but the mediator and their staff are going to be confidential as well. So little chance that your utmost secrets come out. Now, the primary advantage of a mediation is that the parties control their fate. And if you've ever gone through mediation, or if you've ever experienced it in any way, or if you see it in the future, I will almost guarantee you that the mediator, who is oftentimes a former judge, will say something to the effect that it's in your hands. In a mediation, you have control. Parties always come into a mediation with some number in their head. A plaintiff has a number in their head that they will accept, which is less than the number they're asking for, and the defendant will have a number in its lawyers' heads of what it is willing to pay, and that is usually more than what it wants to pay. So in a mediation, the parties can control their fate. It's the only time in a dispute in which the control is in the hands of the parties. If a case is not resolved at mediation, then inevitably it's going to be a judge or a jury who decides the case. Now, furthermore, a mediation agreement, if you reach a mediation agreement, it becomes a contract, and it can be enforced in court. So even if a party decides to not abide by the mediation agreement that they made, you can now sue for breach of contract without having to prove the underlying claim. So that's a big advantage. But mediation has disadvantages as well. First of all, mediation relies on each party having a good faith desire to settle the case. The parties, unless they want to engage with one another, if the parties are not willing to compromise, then the mediation becomes a waste of time and energy and money. So mediation ultimately relies on each party wanting to settle the case. Mediation does not provide any way of discovering items, to get items from the other side. So oftentimes mediation fails because you have to go through litigation anyway in order to obtain evidence from the other side. And therefore, parties, once they have started litigation, are inclined to remain in litigation. And finally, even if there is a mediation agreement reached which is enforceable, it still requires court intervention, which means you may be back in court even though you didn't want to be. Another aspect of mediation, another disadvantage, is that it really prevents the growth of the common law. Remember, the common law is based on the idea of an appellate court issues an opinion, and that opinion not only is the law, but it also provides guidance for every other entity that's going to be involved in a situation similar to that court case. And so if we lock all of our disputes away in these private resources using things like mediation and arbitration, then the common law does not do what it is supposed to do. It's the same problem with arbitration as well. Now, arbitration is a formal means of dispute resolution. Arbitration is a technique for the resolution of disputes outside of the courts. The parties to a dispute refer it to arbitration by one or more persons, those being the arbitrators, or usually an arbitration panel is what we call it. Oftentimes there are 3 members of this panel. Each side selects one member of the panel, and then the 2 arbitrators then select a 3rd arbitrator in order to avoid any ties and to ensure that we get a decision. And when you enter into an arbitration, you agree to be bound by the arbitration decision, which we call the award. Now, in an arbitration, a third party, the arbitrator or the arbitration panel, will review the evidence, much like a court would, and impose a decision that binds both sides. And that decision is enforceable in court. So if you are engaged in an arbitration, you must abide by the arbitrator's award, whether you think it's fair or not. There is generally no appeal of an arbitration award. This is the most important thing for you to remember for your test, because I'll put a problem on your test and I'll indicate that, well, this doesn't seem right. But the fact is, once you're in an arbitration, you have agreed to whatever the result of that arbitration is. There are very limited rights of review and appeal of arbitration awards. Now, finally, arbitration is also binding in another way, because both the agreement to arbitrate as well as the arbitration award are binding. If you have agreed to arbitrate a dispute in arbitration, you must follow through. You are bound by that agreement. And oftentimes, parties will enter into arbitration agreements when they first enter into a relationship, whether that's a contract for the sale of goods, or whether it's in employment, or whether it is for a cell phone service or credit card. You have undoubtedly entered into an arbitration agreement in your life, because once you sign one of those agreements, you are bound by the result. Now, arbitration is widely used in the United States in a number of different ways. First of all, in consumer transactions, like I said, credit cards or cellular phone services. If you belong to Xbox, if you have an Xbox ID, you've agreed to arbitrate any disputes between yourself and Microsoft. So consumer transactions routinely include an arbitration provision. Recently, employment agreements have often included arbitration provisions, which would require you to arbitrate any dispute arising out of the employment relationship, not just the contract of employment, but any dispute. So if you allege racial discrimination, for instance, you may have to arbitrate that rather than filing your claim in a court of law. Civil rights are subject to arbitration agreements as well. Now, arbitration is governed by statutes, and in the United States, the most important arbitration statute is the Federal Arbitration Act, sometimes referred to as the FAA. This statute governs most arbitrations. Now, every state has its own version of an arbitration statute. However, if there is a dispute, if there's any sort of conflict between the state statute and the federal statute, it is the federal statute that applies. Arbitration resembles a court case, which is to say the arbitration proceeding is adversarial, just like with a court case. It is often requires the use of attorneys. And at an arbitration, the parties will present evidence and witnesses just as if they're in a court, but instead they're in a conference room. Now, the rules of evidence don't usually apply to an arbitration proceeding. This is one of the reasons why arbitration moves much faster than litigation is that there's no need to restrict what the finder of fact, in this case the arbitrators, to restrict what they're going to hear. With a jury, you have a lot of concerns. With an arbitration panel, everything comes in and we leave it up to the arbitration panel, who has expertise to decide what is relevant and what is not. As I said, arbitration is a binding procedure. It is conducted in front of a neutral third party or multiple parties. And of course, there is no appeal of an arbitration award, even if the parties agree to an appeal. In this case, out of the Supreme Court in 2008, it concerned a dispute between a real estate company, Hall Street Associates, and Mattel, the maker of Barbie. And in this dispute, the parties agreed in their arbitration agreement that if either party was unsatisfied with the arbitration finding, that party could then file a lawsuit in federal district court. The Supreme Court disagreed with that notion. The Supreme Court did not want the federal court system to turn into an appeals court for arbitrations. And so the rules of the FAA say then arbitration is binding. So even if the parties agree that it should not be binding, it will be binding. Now, arbitration has many advantages and some disadvantages as well. Let's talk about the advantages. First of all, it's relatively low cost. It will cost you more than a mediation would, but much less than going all the way through a jury trial. It is relatively quick. Now, you can't hear a case in arbitration as fast as you could in a mediation, but within 6 months, you could have a dispute resolved in arbitration. You may not need an attorney. Arbitrators don't necessarily need an attorney. It's easily accessible, meaning there are less formalities than there are in litigation. Oftentimes, you simply fill out a form, pre-printed form or something online, and make a claim. The arbitrator has expertise. The arbitrator will be familiar with the context of the dispute. So if it is an employment claim that's going to be arbitrated, the arbitrator will be familiar with employment claims, and so will already have knowledge and won't need to be educated in the way that a jury would, or potentially a regular district court judge would. There is certainty because of no jury. The jury introduces a great deal of uncertainty into any dispute resolution. This is where we get the whole idea of nuclear verdicts, and an arbitrator is unlikely to do that. In fact, studies have shown that arbitrators usually split the baby. They will force one person to pay more than they want to pay, but they will then not force them to pay as much as the other side wants them to pay. Arbitrators tend to find something in the middle because that's how you keep getting business as an arbitrator. One of the big advantages of arbitration, which is rarely discussed, is you will have a chance to tell your story before a neutral third party. Now, in litigation, there is no guarantee that the court will ever hear your side of the case. The court can grant what is called a summary judgment, which is to say there's nothing here to decide, and the court will end the case on its own. In an arbitration, you are almost certain to have the opportunity to tell your side of the story. Arbitrations are confidential, like with mediations, meaning the arbitrator, the arbitration panel may be aware of the dispute or the facts underlying the dispute, but no one else will. And finally, finality. There is a lot to be said for having a decision issued quickly and having that issue not subject to appeal. When the case is over, it's over. And two parties that have previously been happy in a business relationship may be able to rekindle that relationship simply because of the finality of the award and the ability to move on rather quickly. Now, there are disadvantages to arbitration as well. First of all, there is the lack of a public forum. I mentioned racial discrimination a while ago. Racial discrimination is a claim that in employment may be subject to arbitration. Well, racial discrimination claims are based on a statute, Title VII of the Civil Rights Act of 1964. These are public laws, but they're being decided in a very private method. Another disadvantage of arbitration is that the arbitrator can be a repeat visitor. And again, we see this problem in employment, wherein the arbitrator will work on behalf or will see the company, the employer, multiple times, but that arbitrator is likely to see you only one time. So the arbitrator has a situation where they are familiar with the company's claims or the company's arguments, but much less familiar with your particular arguments. Because of its binding nature, because courts don't look past the fact that there's an arbitration agreement, unfair procedures may be put into place, and parties are bound by these unfair procedures. There's generally no appeal of an arbitration award, which we said was a positive, but also a negative. If the arbitration award is much different from what you expected, there is no right to appeal that. What we've seen in recent years has been the growth of mass arbitration claims. So you have a situation where an employer requires its employees to sign an arbitration agreement. However, if it's a situation where attorneys are making the claim that the company's not paying minimum wage, then they will file thousands of arbitration claims, and therefore losing the key advantage of arbitration being quick and inexpensive. And just as with mediation, arbitration prevents the growth of the common law. So in conclusion, what did we learn in this lecture? Negotiation provides the most inexpensive and efficient means of dispute resolution. Mediation uses a neutral third party to resolve disputes and an informal procedure. And arbitration is a formal means of dispute resolution that binds the parties to the result. That's a lot of information we covered rather quickly, so if you have any questions, please let me know. I will try to post some more information about arbitration and mediation. I have done many of these over the years, probably hundreds of mediations, and so I do have a lot of knowledge about how they work, and so I will be happy to share those things with you if you just let me know. Thanks a lot for listening, and I will see you in the next one.